want us to? Where do you want us to sit here? Just this podium thing is sort of in the middle, eh?
Although there are a lot of people who haven't arrived yet, maybe they can't start their cars on this cold day, we're going to thank everybody who did make it on time to this Saturday morning program on what civil litigators need to know about criminal law. We hope you take some time to fill in the great course evaluation forms in the binder because they help us with our future programming. And we want you to note that to increase access to CLE in the province, we are videotaping this program. My name is Helen Bernstein. I'm Counsel Program Development at the Law Society, and welcome to what I believe will be a really interesting morning for you, chaired by Brian Greenspan, Terry O'Sullivan, and Chris Paliare, all prominent members of the bar. We thank them and all the members of the faculty for all their help in putting today's program together, and please welcome your chairs.
Good morning. Thanks for coming out on such a cold day, although it's warmed up to -9. We have an amazing group of criminal and civil litigators today. We called in a lot of chips to get this group together. Brian Greenspan, co-chair, Chris Paliare, who's going to chair the first panel. Because we have such a busy schedule, and because each of these topics could run easily for an hour or more themselves, we're going to try to keep it moving pretty briskly. There may not be time for the questions or as many questions as you'd like, so try to pigeonhole your people at the break if you have questions. As I say this, we're really grateful to so many top lawyers for joining us on a Saturday morning. Because we are hitting the highlights, I'm told by Brian that what we really need to take away from this as civil litigators is that as soon as we recognize one of the problems identified today, we call one of the criminal lawyers and don't mention the word certificate in any of the conversations you have with them. So we're going to start off with the first panel. Co-chair Chris Paliare is going to chair this panel, and he'll introduce the people who are with him. Chris?
Thanks, Terry. On my left, somebody needs really no introduction, Eddie Greenspan. On my right, Fletcher Dawson from London, to whom I have to give a great deal of thanks for authoring the absolutely excellent paper that he has put together. And I don't want to spend any time on introductions because time is limited, and might as well move to the topic since we have these two well-known and superb criminal lawyers here. Let's get some information from them. Let me begin by saying, what do you do, Fletcher, when the police come either knocking at your client's door or they have invited your client to come to the police station? What should the members of the audience do?
Stop it as quickly as possible, would be the short answer. It's good at that point in time to try to maintain a polite attitude because you don't really know where it's going, but you've got to be pretty firm. And you know, I usually try to speak with the police and get them sort of to agree to hold off till the client can get into my office. If there's a meeting arranged, I don't let the client phone to postpone it. I get instructions to do that, and I phone and postpone it. And you know, I sort of leave the door open to the police, even though I probably we'll tell them later if there's anything at all that we're concerned about that my client isn't going to talk to them. But you know, if you hold out the hope of advantage to them, the hope that they might get a statement later, sometimes they're a little more cooperative. But you've got to tell the client immediately not to say anything. The client shouldn't be letting the police look around. If the police don't have a search warrant, the client shouldn't be allowing the police to take anything away with them. And what you want to do is get the client away from the police and into a position where you can find out what's going on, or consult with criminal counsel and find out what's going on.
Well, Eddie, just on that point, if somebody isn't under arrest, can they refuse to speak to the police, and can they refuse them entry into their home or their office?
They can actually refuse to speak to the police, whether they're under arrest, under suspicion, not under suspicion, or in police custody at any time, and they probably should. It's very important that we all have clients or potential clients who think that, oh, let me just talk to them and I'll explain it and they'll go away. You have to understand that police don't go away, or at least the police I've dealt with don't go away. And that to serve and protect is really to serve and protect everybody except the people that you act for. They do not serve and protect them. When it comes to this stage, getting a statement is what they want, and they want to talk and they want to make it look like, I mean, they tell citizenry that you must come with us. You don't must come with them unless they arrest you. And they want to get you in a position where you want to talk, and you don't know what your client's going to say. You have no idea. You've not discussed it with them, so you have to do your best to postpone it, and then do your best to make sure it never happens, the interview, unless under certain circumscribed rules that we'll talk about.
One of the things I found interesting in your paper, Fletcher, was this concept of an involuntary statement. Can you tell us how that works and what a lawyer might do to participate in assisting the police on the one hand in order to try to extricate themselves from being with the police, but on the other hand, not incriminating themselves?
Okay, well, the first thing I'd say to a group like this is you got to recognize this is only something you do with a great deal of caution after you've done a lot of due diligence and really looked into the situation. And there might be circumstances in which it appears to you that the client does have some exposure, but the police really don't seem to be targeting your client directly at that point. They're really more interested in somebody else, or at least you think, you know, they may leave your client alone if they really get what they want on someone else or some other situation. And so you know, you go back to the rule of voluntariness. A statement is not admissible in evidence if it's induced by fear of prejudice or hope of advantage exercised or held out by a person in authority. So you can usually use that rule to have a statement taken in circumstances where it's deliberately involuntary. Now, this isn't without risk, and it needs to be done very cautiously, and you have to be really careful about this. I would like to try to get an express agreement, and the agreement has to be broad because it's got to be clear that the statement isn't going to be used in any way. It's not going to be used in any proceeding. It's not going to be used for the truth of the statement. It's not going to be later used to cross-examine on credibility. And but this is a device that's not infrequently used in these kinds of situations.
Eddie, can you give us some advice as to what you can try and do to prevent the police from interviewing your client? That is, how do you get them to stop talking to your client when you know your client doesn't want to speak to the police, and you're at your office? What do you do?
And they're with the client?
They're with the client.
I think you have to make contact with the client, and the police leave the room while you're talking to your client, and then you explain to your client that nothing should be said to the police unless and until they've spoken to you, unless and until you've had an opportunity to discuss the matter. And in fact, you can discuss the matter with your client. You can find out just how not guilty they are, and then say to the police, look, you know, I really get the police back on the phone and say, look, I really need an opportunity to explore the client. I think there may be a statement here that we might be prepared to give you, because you can lie to them just like they lie to you, just like they lie to you. And then you get your client, you talk to your client, and you say, you know what, I don't think so. The trick is to try to make it look like you wish you could give them a statement, but you really, in the circumstances, aren't going to do it. You depend very much on knowing the police. You depend very much on your long relationship with them to understand whether or not they're really saying to you, look, we spoke to the complainant, and we don't even like this case. And if you know somebody well enough and long enough that you can trust it, then you may be interested in not having your client give a statement, but having you say something to them about what your client's position is. But you must try to avoid at all costs the giving of a statement. If you have to, it's got to be under the circumstances that Fletcher says. It's got to be the first thing said before the statement, that this is being given for a hope of advantage, and the hope of advantage is that you'll go away. Or it's being given out of fear of prejudice, that if we don't give this statement, you're going to charge us. And then once that's said and agreed to by the police don't agree to it. You know, it's a subjective objective test in terms of voluntariness or involuntariness. So if they don't agree to it, I think you have to take a walk. But don't believe for 1 minute that your client's going to make them go away. Because the one thing you're never going to know in the context of this relationship with the police is what they know. They don't, you know, if you said to them, well, before we talk, I want to see everything you've got. They're not going to show you that. And if they don't show you that, why would you ever talk? Because your client may in fact give what you think is an exculpatory statement and then leaves a critical thing out that he 2 years later says, you know what I remember, or a year later, I remember there was something else. Well, that something else that's remembered is going to cut the legs from under your defense.
There's some little tricks of language that you can use. As Eddie says, you know, knowing the police for a long period of time is helpful, but there's kind of a lingo that's almost, for example, if the police wanted to interview my client, the first thing I might say to him with a squint in my eye is, well, do you want a caution statement? Now, whether the statement's cautioned or not won't affect its admissibility. But, you know, I usually find if the police suggest to me that I mean, if they tell you they want the statement under caution, at that point you know your client's a target. That's the end of it. That is just the end. There are no statements. If they say, well, you know, no, it's not a caution statement, you're getting just a hint, which might be a trick, that maybe your client isn't a target, maybe they're looking somewhere else, and then you can progress carefully from there.
Let me move to the next topic and ask Eddie, what do you do when your client's arrested? We've now moved from the police at the doorstep of your client where they want to talk to him. They now arrest them. What do you do?
Well, then you're called?
Yes. Yeah, you're called.
Then you're called by the police to say your client wants to speak to you, because oftentimes you don't get a call until you're notified that there's a bail hearing, or till after they're released and after they've talked.
Well, wait a minute. In my naivete, I thought everybody's entitled to a phone call.
Yeah, either they say it or they don't say it. A lot of people say that it's not told to them that they have a right to make a phone call. I'm not so sure about that. I can't imagine police officers being, well, maybe they can be that stupid, but I doubt it, because I think people are in such an extreme state of stress that they don't hear it, and that it probably gets said. I don't think it gets emphasized. I don't think they hand a phone over and say, you know, I really want you to call a lawyer right now. I think they probably just say it quietly and quickly and move on. But they often get by that hurdle without that phone call being made, unless people understand that they have a right. And oftentimes it's too late, and they say they gave them the right and he waived the right. So that if you get them on the phone after they've been arrested, you have to have a pretty quick talk with them and make sure they understand that they should not say anything at all. And then you say the same thing to the police. I've spoken to my client, not prepared to talk to you until he's met with me. And you repeat that to the police, and you tell them to write that down in their book, that you just told them that, and that's the way it's going to be. But you can never encourage a client to give a statement until they've talked to you.
And do you find, Fletcher, that the police engage in psychological tricks to try to get the client to talk, even when that has been said to them?
Of course, I mean, just because you advise the client not to talk doesn't mean that the police want to stop asking questions when they hear the client repeat that their lawyer advised them they should remain silent. And typically what we hear about later, or sometimes see on videotape, is, well, you know, your lawyer doesn't know what we know, You know, it's really, really unfortunate you should say that, John, because we have to make some decisions here pretty quickly, and we'd really like to have your side of the story. And as Eddie said earlier, I mean, people are in a lot of stress, I mean, especially non-experienced criminals, the kinds of people you would likely come in contact with. The experienced people, they know immediately to call the lawyer. And when you tell them that they have the right to remain silent, they tell you all the reasons why they're going to follow that advice. But that's not the case with the type of people that you'd often be dealing with. And so what I do is I really try to have a pointed, careful conversation with the client. I tell them, not only do you have the right to remain silent, and not only should you exercise it, but you got to understand, nobody can later point to that and say, because of that, you are guilty or you appear to be guilty. That's not admissible, generally speaking. Judges understand the right. You know, I know that your mother told you if you broke the window across the street when you were a kid, you should go knock on the door and apologize to the lady and offer to pay for it. But that is not the situation here. You must remain silent. Then I go on and tell them that the police probably will continue to ask you questions anyway. And I go on and point out to them that they should just stand fast in their position. And then finally, I usually tell them that particularly if the statement is being videotaped, if the police are persistent, they should at some point just look at the camera and say, I want to speak to my lawyer now. And in every case where I've had really persistent questioning and the client has asked again to speak to the lawyer, that's interrupted the interview. And at that point, you know, you get the client out of the situation. Hopefully they call you, you give them the advice again, and then at that point I usually complain to the cell block sergeant or the person in charge of the detention unit. I ask them to make notes about it. So I think you got to prepare the client for the psychological onslaught that's coming. I'm sure Eddie's seen all kinds of these.
It's very hard. I just want to add something, that you can't give your client 20 things to do or not to do. I mean, they aren't going to, I mean, if they've been arrested and they're in this heightened state of anxiety, and you're going to start giving them a lecture about this, you know, you're like a first-year lecture in criminal law about what to do and what not to do, and under Hebert in the Supreme Court of Canada, that if you invoke your right to remain silent, and therefore you've got a Section 7 right not to be talked to by somebody who they're going to put in the cell with you, who's a police informant, or somebody who's an undercover officer. You can't go through all this. Just tell them to shut their mouths. Okay? Shut your mouth. You say nothing to nobody until you have talked to me. I think that kind of gets the message home. Don't talk. I'm telling you, don't talk till you've talked to me. That's what you're telling the police. That's what I'm going to tell the police. And that's what you do. And when you're in the cell, shut your mouth. Don't talk about this. Just don't talk about this to anybody but me. And that's I think, the message you've got to get out very quickly. You know, if you say to them, look into the camera and say, you know, I want to talk to my lawyer, you know, you may be buying them some bump on their head for saying that into a camera. I mean, this is rough stuff. You know, the police have got you. You know, when you talk about in case law where we've got to show psychological compulsion, psychological compulsion is a fact of life from the moment they walk into the police station. It's one accused, it's one target against several cops in their home turf. I mean, it's bad. It starts bad, it ends bad. It's just never good. And saying anything is never good. I mean, maybe you've got maybe there's some guy who's genuinely going to give an explanation that is going to end the investigation. You don't know that. You simply don't know that, and you aren't going to know it for probably a couple of hours until you've had a chance to talk to them. And then maybe you'll call up and say, you know what, this guy's really innocent. And here's where he was on that day. And then they'll go and prove that he was lying about that too. Okay?
See, I guess what I find is, unlike Eddie's clients, mine don't listen to me when I tell them just be quiet. I mean, I'm always amazed by that.
Well, it is an intimidating process.
You can charge them double when they don't listen. Or triple.
That theme that Eddie has just articulated is found in Fletcher's paper in spades. Don't talk. Don't say anything. That is really thematic. I'm I want to finish with one question because it's topical. What do you do when your client is arrested for drinking and driving offenses? And of course, a very well-known and prominent premier would have benefited from listening to this, I think. But Fletcher, do you want to just give us a quick rundown? Because this is something that I think people here may get contacted about
Sure.
from time to time.
Very briefly, just the main advice is they have to take the breath test. I mean, there are some circumstances where they don't, but it's very difficult to try to evaluate those when you get a phone call in the middle of the night and you're talking to someone who's got a snootful. By and large, you know, they have to blow. So you tell them that they have to take the breath test, but they don't have to do any physical sobriety tests. They don't have to answer any questions. So I tell them, you know, give them your name, your address, personal particulars, answer no questions, and don't do any physical tests, but you must provide breath samples. And the police are entitled to more than one sample, and commonly they seek 2, but they're entitled to actually more than 2 if they need them. So you just got to make it clear to the client. Breath samples, no other information.
And I hope they have enough wherewithal to be able to absorb your information, I guess. Eddie, any other advice with respect to drinking and driving?
You know, if they're sober enough to understand you telling them that they don't have to perform physical sobriety tests, but they've got to give breath samples. I don't know what else you can tell them. Although I mean, it's not like I do a lot of impaired driving cases, but there's an entire body of law out there. An entire body of law. I'm very uncomfortable at advising people because I don't know that entire body of law. So I try to get somebody that does that work on the phone right away to tell me what to tell them. This is a very specialized area of, you know, they have their own motor vehicle reports, and these cases come out a dime a dozen. Some work at the lower courts until they're, I mean, your window of opportunity is when you got a lower court case that hasn't yet been overruled by the Court of Appeal. And that's what you're looking for, and you have to be up on that in order to be able to ask them some questions fairly quickly as to what you should or shouldn't advise them.
And there are specialized criminal lawyers
who do that, and that's who I call.
Can you give me 30 seconds on what to do when the police show up with a search warrant?
If the police show up with a search warrant, there's precious little, leaving apart the solicitor-client privilege.
Somebody else will deal with that.
The solicitor-client privileged area, that you want to get there as quick as you can in the hope that you may know these police, in the hope of looking at the search warrant or having it faxed to you right away so you can talk about the terms of it. And generally speaking, when they're coming with search warrants, if it's to business premises, we're going to know who the police are. There's going to be a number of them, and you're going to know somebody in that team. And you can try to limit what they take. One of the critical things is not only limiting what they take, but making sure that this business isn't shut down by them taking the, what do they call it, the hard drive. I even know that now. And you've got to avoid them taking that. But the limiting of it is what you're trying to do. And most of the time, you know, they're in heat when they come on a search warrant. They're like dogs in heat. They want to take everything, and they're going to take everything, and they're going to be over expansive in what they take. They're in heat all the time when they're in their station and on their home turf and executing a search warrant. And they aren't nice people at those times. Other times, they're not bad. I haven't found those times yet, but I'm convinced that there's times that they're not bad. But there it's trying to limit the scope of what they take. And there's no other way you can do it other than by schmoozing them.
One of the things about the hard drive that I found fascinating about the paper that Fletcher did is that there are sections in the criminal code where they can require the people who own this equipment to run stuff off of it.
Absolutely.
For the police. I mean, you talk about lack of self-incrimination. That may exist from time to time, but in that area, there are specific sections. Maybe just
Well, there are two sections in the criminal code that provide that the police can operate the computer equipment that's on a premises they're searching, and that they can require people there to operate it for them. They can also use any photocopying equipment or other data copying equipment that's there. Now, given this,
Can you send them a bill for that?
Unfortunately,
25 cents a copy?
No. But one thing to keep in mind is, as Eddie said, you're trying to limit the scope of the search. So if you can get over there, you want to have a meeting with the in-house IT guy or whatever, and figure out how you're going to manipulate or operate that computer so that you get, the information they're entitled to under the warrant, but not other information.
In other words, even though that's a bad thing I remember I was very upset when I first saw it, but it actually allows the people that are running the computers to possibly limit it. And they can be helpful, and so that they're not overreaching.
Thank you very much. And Brian, the next panel.
As we're changing panels, just in terms of the outline and the structure of this morning, as you perhaps have, it's pretty apparent and pretty transparent that each of the panels is chaired by a civil litigator. The wings are occupied by criminal lawyers. The moderator, the civil litigator, is meant to ask certain questions to bring out from the criminal lawyers the type of information, hopefully, that will be useful to you. The second panel, and there is some overlap, and we apologize for that, but there's some complex areas that will come into play later in the morning that seem to have some overlap at least. The second panel of the day is maintaining privilege when there is a search at your office. Sandra Forbes moderating, Frank Addario, and Harry Black on the wings.
Thank you, Brian. Good morning. Section 488.1 of the Criminal Code set out a mandatory procedure for the search and seizure of documents in the possession of a lawyer until it was struck down by our Supreme Court as unconstitutional in September of 2002. The court chose, and this was in the Levine decision, which is referred to in the outline which we provided to you in the materials. Instead of rewriting that section to fix its problems, the Supreme Court decided to leave it to Parliament. And in the meantime, Justice Arbour set out a list of guidelines which the court held should be followed in the meantime. And those guidelines are also contained in your materials. And in many respects, those guidelines raise more issues and problems than they do solutions. So what we hope to accomplish this morning is to touch upon what we think are the more major issues and give you some practical advice on how to deal with them. And just to leave one thing with you, the real focus of the guidelines is to bend over backwards in many respects to protect solicitor-client privilege. And the question really is whether they go far enough to do that. And the first issue that we're going to talk about, and I'd ask Frank to address this first, is what do you do when the police officer shows up at your office with the search warrant? What do you do at that time? What do you look for on the search warrant? And should you be thinking about or considering trying to stop the search or challenge the warrant before the search actually proceeds?
Well, the first thing I would say is, in relation to the second question, is you can't really stop the search when the police are there with the warrant. You won't have access to your weekly court judge at that point. So you have to kind of think on your feet and think about what you can actually achieve in the situation. And it's, I think, surprisingly more than you'd expect. The first thing is you will, unless the cops are completely crazy, you will almost always be given a copy of the warrant. And that's going to assist you because once you read it, you'll see the list of things to be searched for, which has to be specified. And it has to be quite particular for a law office for the search to ultimately survive a subsequent review in the courts. The second thing is that unless you yourself are a target, you will generally find that the police are cooperative in identifying the documents or materials that they want. And if you are motivated, as you ought to be, to protect the privilege of your other clients, you will want to assist them in locating those documents in general. But the third thing is that, in discussion with Harry a couple days ago about this, we agreed that there is ample room for negotiation with the police. They will often, at times, identify all materials relating to, Acme Corp as the things to be searched for, when in fact, what they're looking for is a specific filing from a particular year, or a specific series of letters that went back and forth between Acme Corp and someone else, or specific exhibits that were produced in connection with some event. And so if the police are in a reasonable mood, and if you've had an opportunity to review the warrant, you can limit quite sharply, I think, the amount of documents that are taken. The other thing I just want to touch on here is the assistance orders that Fletcher and Ed Greenspan referred to. There's a provision in the criminal code, relatively new, that essentially deputizes anyone that the police choose to name in the warrant, and they can persuade a judge should be deputized, to act as their agent. And in all likelihood, they will increasingly use these in relation to law office searches, in part to restrict the scope of the search. And I think you'll increasingly find that in the text of the warrant, you will find an assistance order or appended to the warrant directing you to locate the documents or exhibits or items on the computer for the police and to produce them for them. And of course, because it's an order naming you or someone in your office, it carries with it consequences, criminal consequences, if you don't comply with it. So those are the things to look for when the police first arrive.
Maybe, Harry, I can ask you, let's assume you look at the warrant and you see that there's something wrong with it. There isn't a particular description of the document or file or client file to be searched. Or you see that perhaps one of the guidelines was not followed in actually obtaining the warrant. What can you do? Can you stop the search?
Oh, I think the very first thing you should do is you have to examine the warrant. And I think what you must realize is that you're not going to expect this event to occur. And when the police come to your office, you will find that it is a very unsettling and upsetting experience, and one that will be new. You're going to be immediately concerned about why are they here, who are they investigating, what is the offense, what do they think my involvement is, am I in trouble here? I mean, these are all the things that are going to be racing through your mind. And the next thing is, you're going to say, holy smokes, what are my neighbors thinking in the next building when they see this big OPP van parked outside my office? They're going to think that I'm involved in crime. So you must also realize that when the police come to a law office, or any office, or anywhere with a search warrant, they're not just going to be coming to execute the warrant. The police use every single investigative step as an opportunity to gather evidence and gather information. And while they can't secretly record you without a judicial authorization, you can be assured that every word you say to the police is going to be with their spin on it recorded in their memo books. So remember this, when you start to speak to the police, there is no unringing the bell. Your words, once spoken, are out there, and they can come back to haunt you, so you've got to be careful. It's like what Eddie was saying about when the client speaks. Well, in this case, you're the one who's got to watch what you say. Now, having said that, you're maybe trying to get over your initial shock, I would think most people would be. You must also be concerned about your employees, because they may not realize that the police have absolutely no obligation, that they have absolutely no obligation they have no obligation to answer any questions from the police. The police have every right to ask them questions. Your employees may not know that they don't have to answer. And, you know, when the police are walking around your office for several hours, and that's what these warrants will entail in many cases. This is a wonderful opportunity for the police to gather information, to ask questions. How often has he been in here, this guy? So, you know, it's an issue that you want to address. You can never tell. Nobody can ever say to another person, don't answer those questions of the police. If he's investigating, if he's in the execution of his duty, the police have a right to go and ask him questions. It's obstruct, perilously close, if not in fact obstruct, for you to say, just a minute, don't talk to him. It's not, however, if you say, talk to him if you wish, bear in mind that you have no legal obligation to do so. How the police might record this assertion by you is a source of potential danger. It may not be recorded in precisely the same terms as you've carefully expressed it. So care is really important. Now, the next thing is, having said all that, you've got to look at this warrant. Who's the subject here? Who is the suspect? Are you involved, allegedly? Do the police think that not only are you the lawyer, but you've been involved in this nonsense? Because if that's the case, there may be divergent legal interests. This is a complex area, and one that requires the exercise of real care. And you're not going to exercise care if you rush, if you hurry. And so you say to the police, hang on here, this is a serious step. This is my office. I'm entitled to the warrant, which means I'm entitled to read the warrant. So hold on. And I'm going to read this warrant. And if it takes me 20 minutes to read this warrant, it's going to take me 20 minutes to read this warrant. So, who's the subject? What are the offenses? What's the time frame? How long has this been investigating? At this point, you are now asking questions, if you can, of the police. There's nothing wrong with that. You say, who's in charge of this investigation? Is it you or is it some guy that isn't here? You're going to need to know that. You want names and you want phone numbers because you're going to have to get in touch with these people. Then you say, how long have you been investigating this? What is this about? See what you can find out. The next thing you've got to do is, you've got to phone your client. You've got to get instructions. And what if your client isn't known? What if it's the numbered company? This was one of the problems with 488 that the Supreme Court said it required you to name your client. The name of your client's also privileged. So is the client named or is he not? You're going to look at the description of things to be searched for and look at the description of the offense to see who are they looking at. So then you're going to get on the phone and you're going to say, now I got to get instructions from my client. And you must realize that you as a lawyer have an obligation. You've got the documents. Since privilege can be lost irretrievably through the negligence of the lawyer, you got to be involved in this search. You have to be there. You have to watch. For example, in the selection of things to be searched for, they're not entitled to look at the document. So you've got to be involved. You've got to know what your own legal obligations are. These are serious issues that arise when the police arrive on your doorstep.
Well, let me follow up on one one of the many good points that you made, Harry. The guidelines that the Supreme Court set out, one of them says that all documents, subject to one exception, but all documents in the possession of a lawyer must be sealed before being examined or removed from the lawyer's possession. And the guidelines also provide that, you know, if a privilege claim is made by your client and it is contested by the prosecution, that the issue has to be judicially determined. So here you're in the position where the file in relation to, let's say, X real estate transaction is going to be sealed, and you know that somewhere down the road, maybe the next day, maybe a week from then, you have to argue a privilege claim in court. So maybe I could ask you this, Frank. Can you give us some tips on what kind of process or procedure you would follow in the sealing of these documents? Can you try and set up a procedure, or are the police going to impose one on them? And what can you do to get ready for your argument, or whoever you're going to retain, to make that privilege claim the next day or so?
Well, the first point I want to make is that at least until this case was decided, I had found that the police had, to politely describe it, as divergent views from me on what was privileged when they would search a lawyer's office. And you would have really peculiar conversations with them about what might or might not be covered by the privilege. Because the guidelines now say everything should be sealed, and because presumably police officers who are coming to a lawyer's office are familiar with this case, you would expect that they would know that everything is to be sealed. But in any event, you need to assert that everything must be sealed. The second thing I would say in relation to that, and this is something I neglected to mention earlier, but I have found it useful when lawyers' offices are being searched for the lawyer, among other things, apart from asserting the privilege, to follow the police around with a dictaphone and make contemporaneous notes or a contemporaneous record of what's taking place, what's said. And I'm not suggesting that you do it in any way that's confrontational with the police, but in such a way so that later on, when we actually learn what the issues are in that particular search, you will have a contemporaneous record of what was said and where they went, and how carefully they attempted to comply with the strict terms of the warrant, or what we hope to be strict terms of the warrant. Finally, in relation to the claim, once you have asserted that everything should be sealed, you need to do two things. One is you need to get instructions from the client with respect to those documents. And the second thing you need to do is to set up as quickly as possible an opportunity for you and the client, assuming the client is, as Harry says, known to the police, to review the documents and determine how you're going to enforce the claim. And since I raised it, I'll just finish that off. Enforcing that claim is relatively easy in the province of Ontario. You can file your motion in the Superior Court, and you can either by way of affidavit evidence or viva voce evidence assert the claim of privilege over individual documents or sets of documents or files in front of a judge. And unless your jurisdiction is severely backed up, you can do it relatively quickly. And this is important, of course, in circumstances where you need to get documents back and or need to get it resolved in order to keep the business running or in order to continue the case for which you've been retained by that client.
Thank you, Frank. Just one practical question. Harry, maybe I could ask you this. Let's assume that the file, there's one file that's being seized, and it's actually an active file that you know you're doing work on. Can you ask the police officers to hold off sealing until you can make a copy of that file?
Oh, you can ask that, and you should ask that, and you should ask for copies to be made. They don't have to do that right then. You may have to get an order, but there's nothing wrong. You've got a law practice, you've got clients, you've got ongoing business. Of course, you ask for copies to be made. you must, but the whole thing here is that the police cannot, if you look at our Boers guidelines, it says, under item 4, except when the warrant specifically authorizes the immediate examination, copying, and seizure of an identified document. I don't know where the authority for that is. How can a justice of the peace take away, when he issues the warrant, your right to have the issue of privilege determined by a judge? I simply, when I read item 4, I said, how does this justice of the peace ever have this authority to do this? So I would immediately challenge that. But so in response to the question, you've got to make sure that when these documents are taken from the files, that the police don't examine them. They go right into the box, and the box closed, and it's taped up, and you're going to sign right over the tape, and that tape isn't going to be opened until it's in front of a judge. They can't look at it. That's it. There is no examination of any document while they're there. And it's a problem, because on the one hand, you've got a description of things to be searched for. On the other hand, how do you who picks them out without, and how does this happen without somebody looking at the document? But you have to try, and you have to minimize the risk that there's going to be that. You've got to make your own record. Just what Frank says about following them around with the tape. You've got to have your own record. Ask them for immediately, you're going to say to them, I'm going to ask you for a detailed list for you to give me in writing, so they can't say later on, well, we never got that document. I want a detailed list with your name on it of every document that you take out of here. So these are some of the things that I don't know, I don't want to get ahead of myself, but in terms of computers, there's a real issue, because I mean, everything is on a computer these days. So he comes and the warrant says, well, I want all correspondence between A and B, and this is on the computer, or it's been scanned, and it's inside this thing. Who does it? I say to the officer, I will get these things. You stand over here. You stand here, and I'm going to show you. I'm going to bring up the directory. This is the directory. I'm operating this computer. You're not. Now, he may say, get out of that chair. I'm going to do it. He may. I mean, there's a section in the criminal code dealing with computers. But you should say, look, I'm going to offer to do this. And not only that, I'm making a note that I offered and you refused. So that if there's any breach here, you're going to hear about it. I think the message is this, that the theme is everything is privileged. Everything, the privileges must be asserted immediately. It must be in total. You must do what you can to without, and you know, a little bit of nerve is important here. You can't wither under the looks and the abruptness of these 7 guys in suits, right? You have to say, this is it. This is a serious issue. The law protects this. And I have an obligation as lawyer to assert the privilege and to protect it. So I'm going to be involved. You know, I'm not going to obstruct you, but I'm going to be involved, and we're going to do this carefully. And by the way, this is going to take a little bit of time.
Okay, well, thank you very much. I think we've probably run out of time. So I would like to thank Harry and Frank for that very helpful advice on what would be a very frightening and difficult thing to face. Thank you.
Many thanks, Harry. No one would ever suggest that you were short on steely nerve, but that was great. Thanks. The next panel will be chaired by David Roebuck, and it's dealing with the disclosure of an allegation of a criminal or regulatory act during a civil trial. In some of the material that was handed out, David Roebuck was listed with his old firm. Just in terms of trying to give him a little plug with the new firm, he actually is a partner with Heenan Blakey, and he is going to have with him Scott Fenton on his left and Todd Ducharme on his right.
And we're going to see who can match Harry's passion. Our topic may cross over on an issue basis into some of the other topics. Peter Wardle has given us a heads up and tried to set lines, but I think some of these issues do come up and may come up again. But I think the views, even if you get more views than my two criminal law colleagues, will not be without value, because some of the issues are quite important. We've tried to create a fact situation as a basis for our discussion, and our fact situation is a civil trial, and this is a fact situation which you've probably seen. An employee has been dismissed with allegations of theft. The employee says, didn't do it. It's a wrongful dismissal, so there's a counterclaim for wrongful dismissal, and there are allegations of theft of money and theft of property by the employee, property such as a laptop, computer, things of that nature, and money. First question that arises, and I'll put it to Scott. What is the standard of proof in this situation, since you're essentially alleging theft as the basis of the dismissal?
The standard of proof is the civil standard of balance of probabilities. And in the paper we've included in the materials, I've cited two cases which set out that proposition. And this issue can come up at both civil trials and regulatory inquiries. For instance, at the Rychuk inquiry, this issue arose. The standard of proof is the standard of a preponderance of the evidence. However, the case law suggests that where allegations are made that have criminal misconduct as their focus, the trier of fact is entitled to give greater scrutiny to the weight of the evidence. Now, that sounds like a contradiction. My assessment is that in an overwhelming case where the evidence of criminal misconduct at the civil trial is particularly strong, this principle, these cases won't make much of a difference. However, in a close case, or where the credibility of the accuser may be substantially an issue, this principle that the trier should have a closer look at the weight of the evidence may just give the trier of fact a hook to hang his or her hat on, to a quarter turn really on the burden, and it may make a difference in that kind of a case.
Well, it sounds like there's something between the civil standard and the criminal standard. Is that right?
Well, there's a huge difference, obviously, in terms of proof beyond a reasonable doubt being the standard at a criminal trial. The question is whether this added twist to the civil standard, that is that the trier is entitled to scrutinize the evidence with greater care, makes the onus, practically speaking, at least slightly higher in the civil case.
Well, another hypothetical situation, and again, I've seen this exact situation happen in a real live case. It's the plaintiff employer that's alleging a theft on the part of the employee, but in the course of the trial, all of a sudden a security guard is called, and you find that the plaintiff is in possession of a document that's actually been taken from the private office of the employee. The document is potentially incriminating, but yet would appear to have been the personal property of the employee, not a piece of company property. And all of a sudden, the issue is live in front of the judge. What should counsel for the employee do? Todd?
Well, I take great comfort from the hypothetical because it's nice to know that civil lawyers confront the sort of things that happen to me far too often with my clientele. I think there are two issues. What's the status of the document and what's the impact in terms of your client? Whether it's theft or not really isn't an issue. I think the more immediate concern is whether counsel who's tendering the document is in possession of property obtained by crime. That would vary between an original document and a photocopied document, as ridiculous as that might sound if the photocopy is from a stolen document. There's a case cited in our materials, Regina and Stewart, where the accused had was involved with a union and got names, addresses, and phone numbers and was of another organization. And was charged with theft. The Supreme Court of Canada ruled that the information was not tangible enough to constitute the basis for a theft charge. You might think that that ends the matter, but it in fact doesn't, because what might often happen is somebody will go to an office, take a document, they don't want to steal the original, so they'll photocopy it and return the document. The photocopy itself could be possession of property obtained by crime, even though the information's not tangible. The paper, the photocopy toner is. And you may think that's ridiculous, but I have a case right now that stems from a very nasty series of divorce proceedings, and that's the basis of the charge. The simple solution for counsel really is whether it's theft or not, you're not going to be able to determine it in the context of the trial, and it doesn't really have anything to do with whether the document's properly tendered at trial. Your concern should be how are you going to minimize the downside to your client who's being confronted with the documents, putting aside the issue of admissibility, whether you've had proper notice of it, whether it was in the affidavit of documents, all these things about civil law that I don't understand. The bad news is there's really no protection against the use of the document in court, even if it was in fact stolen. There may be subsequent issues down the way relating to the plaintiff's conduct, the plaintiff's counsel's conduct, but none of that's going to give your client any comfort at the particular moment. So about all I think you can do is either attack admissibility or get into the bona fides of the document. And of course, if your client looks at the document and says, oh yeah, that's the letter I wrote on such and such a day and that's my signature, you're not going to get very far on that.
Well, let's take the hypothetical and give it another little twist. Let's assume that plaintiff's counsel comes into possession, a security guard or whatever, somebody got the document out of the employee's office. It is the original, and it seriously implicates the employee. Now, you're conducting a civil trial. You're the lawyer for the plaintiff. But suddenly, you're in possession of a document that seems to evidence the commission of a criminal act. And in addition to your natural desire to spring this upon the other side, what obligations do you have with having come into possession of evidence of that nature?
Well, there are two areas that should be of concern to you. One is the possibility of criminal liability. The other is the possibility of some professional misconduct relating to the Law Society. I think in terms of the criminal liability, again, the concern is it property obtained by crime? I think the simple answer is you take a photocopy of the document and return the document to your client. You don't take it into your possession. Now, when you return the document to the client, you can inform them that it's an offense that they're committing. If they're in possession of stolen property, you can inform them that they can't destroy the document. But if you only took one thing away from this part of our discussion, it would be stay away from the document. Don't take it into your possession. With respect to the Law Society, The issue really becomes engaged in whether or not the document might be considered physical evidence of a crime. There's two different issues here. One is whether the document per se is a document obtained by crime. It may also be evidence of a crime, some other crime that has been committed. And it undoubtedly seems like an enormous leap, but the analogy that you want to be concerned about is whether this letter is going to be analogized in any way to the videotapes in the Ken Murray case. I sat on the Law Society, as you may know, struck a committee to deal with the issue of lawyers being in physical possession of evidence relevant to a crime. And what was interesting about that was, at least at the outset, all the civil lawyers that we talked to seemed to have this belief that, well, smoking guns are one thing, bloody shirts are one thing, but somehow documents aren't. And I can tell you that at the end of, we've not passed a rule, but at the end of our discussions, we concluded there was no principled basis to distinguish documentary evidence from more traditional forms of physical evidence. Now, there's no question that there are clear differences. A document's less likely to be considered an instrumentality of the crime, which was an important issue if you look in Murray. But the important point, I would say, is, again, you take a photocopy of the document. If you take possession of it, I can tell you that I have no doubt that the Attorney General of Ontario would take the view that you only have 3 options. I won't get into the details because of the time, but if you look at the Murray case, which is cited in our materials, at paragraph 124, the trial judge there said you either have to immediately turn the tapes over to the prosecution, either directly or anonymously through another party, you deposit them with the trial judge, or you disclose their existence to the prosecution and prepare to do battle with them. And you don't want to get into that situation. And that's the concern. And judges, we certainly found on our work in the committee, they don't want to be put in the situation of having to be custodians of these sorts of materials. So if you don't take it into possession, you avoid the whole possibility of having to get into that sort of morass that's just going to be a problem for you.
The document, the incriminating document, is now before the court. The plaintiff is trying to confront the defendant with it. What issues arise? What protections are available? And what should the lawyer for the employee be doing?
Well, this I think goes probably to the heart of what this topic is all about, which is in the midst of a civil trial, there's an allegation of criminal misconduct. Now your client's being cross-examined, or during his cross-examination, there is specific cross-examination on this incriminating document. He's being pressed to admit that he's committed an offense. It's very important that the client and any other witness who may be faced with this situation gets legal advice about the importance of invoking Section 5 of the Canada Evidence Act. Todd's going to talk a little bit about the coextensive protections that Section 13 of the Charter offer, but in the Neubould case decided in October of last year, the Supreme Court of Canada set out the importance of Section 5.2 of the Canada Evidence Act in protecting against any subsequent use of the incriminating testimony of the witness from the prior proceeding. The reason, and I'm going to cut to the punchline on this, as to why, practically speaking, in my view at least, it's important to raise Section 5 expressly at the moment the jeopardy arises for your client or the witness, is that if down the road there are criminal proceedings, and there is a voir dire held in those criminal proceedings as to whether the Crown's use of that witness's testimony is for a purpose to incriminate the witness, the fact that Section 5.2 has been invoked at the civil trial or the prior proceeding may be important and of assistance to the trier in determining whether the subsequent use is for an incriminating purpose as opposed to just to cross-examine for impeachment purposes.
This is a situation that comes up practically in civil cases. Civil lawyers generally are reluctant, if I'm acting for the employee, I'm reluctant to underline the potential criminal liability by invoking Section 5. And but now that we know that the Charter has come about and we have Section 13, I think there's some civil lawyers who think that, why should I invoke Section 5? I have Section 13 of the Charter automatically. Is there something that I don't get under the Charter that I do get under Section 5? Todd?
Well, just a 30-second answer. What you get under Section 5 is you get the, as I indicated earlier, the declaration at the moment the jeopardy arises in the prior proceeding. So attention is focused. I take your point that in the ordinary civil case, you don't want to stand up at the outset of your client's testimony and just say, Your Honor, my client is taking the protection of 5-2. You wait until the jeopardy arises. But if that occurs, the protections that Section 13 offer are really the same that 5-2 under the CEA offers, which is a complete ban on the use of the testimony, save and except for a subsequent prosecution for perjury or giving false testimony.
Then Todd, can you comment on the implications of the Charter, 11C or 13, in this particular fact situation?
Sure. Well, 11C is simple. It provides that any person charged with an offense has the right not to be compelled to be a witness in proceedings against that person in respect to the offense. So there are two important details there. One is the issue of compulsion. The other is the nature of the proceedings. And in this case, the latter resolves the matter. The person in the civil trial is not charged with the offense. And the proceedings are not in, and even if they were, the proceedings are not in respect to the offense. If he was charged with the offense, one presumably would be doing everything one could to delay the civil proceedings until sometime after the resolution of the criminal matter. And while that resolves the matter with respect to 11C, you should keep in mind as well that if somebody with counsel is testifying, they can't choose to testify in a civil proceeding. They can't very well be said to be heard to say, well, I'm being compelled to testify. They clearly not. It's voluntary. The case Dubois cited in our materials recognizes that distinction.
We've got 2 minutes, so and I want to get at least 1 minute on this issue of direct and derivative use. So in a situation where there's a subsequent charge with respect to, for example, income tax evasion because the employee didn't declare the money, is the Evidence Act a protection in a non-criminal, something outside of the criminal code area?
Well, in a prosecution under the Income Tax Act or other tax statutes, and I've listed them in the paper, but the most well-known and frequent are the 239 prosecutions. Definitely all of the protections under Section 13 and 7, which we may get to in a second, would apply. And have a look at the Jarvis decision, which certainly says that in a criminal prosecution or a criminal investigation, all of the protections of the Charter do apply. Just one practical issue to think about. In this fact situation, if the client, however unrealistic this fact situation is, if the client is going to end up disclosing that he or she has not reported all of her income, it would be very important to think about a voluntary disclosure to the CCRA almost immediately, because if you can get to the CCRA before they've commenced an audit in respect of unreported income, and the client is otherwise truthful and fully cooperative, you can take advantage of what is in effect an immunity program under the tax legislation that applies to various pieces of legislation.
Well, I don't think we have time to take a new topic. If you want to just give one comment on the Neubould case?
Well, Scott mentioned the Noel case, which the next panel will be discussing, no doubt. But it's important to note that if if there are incriminating admissions made by your client in a civil proceeding, that can't be part of the Crown's case in chief. That's clear through the various cases in the Supreme Court of Canada. The issue has always been, what can you do in cross-examination? The question there was, and in a case called Culdeep, they said, well, you can cross-examine them if they say one thing at the civil trial and something else. You can use the inconsistencies to impeach their credibility. If you look at the case of Noel, he admits to committing a murder in one case, and then when he's tried, he denies it. The Crown cross-examined him extensively on that. It was 250 pages of the 299 pages of the cross were on the previous admissions. In that case, the Supreme Court of Canada said you can't do that. And the test that they applied, which is a very important change, is if the prior evidence was incriminating at the time it was given, in that it contained a damaging admission, its subsequent use is totally prohibited unless there is no realistic danger of incrimination. So if on a subsequent proceeding someone's saying, hey, we're just getting into this for credibility, you can shut that down now that Noel has been decided. And the obvious concern there is, how does a jury or a judge put out of their mind a confession made in the civil context?
That's it. Thank you.
Thank you. Well, our next panel is coming to the podium. Let me introduce them. The panel is going to be chaired by Peter Wardle, as a partner at Kelly Affleck, author, teacher, well-known civil litigator. His wing persons today will be Jane Kelly, Kelly Jennings, and Frank Marrocco of Gowlings. Bambi Ben Bennick here today, Frank? No, she's not.
She's not supposed to.
All right, we're gonna cut right to the chase. There is a lot of overlap between the previous topic and this topic, and believe it or not, the people who will come after us will also be getting into some similar issues. So, for what we're going to do, we're going to assume you're first in a piece of civil litigation, and there are parallel criminal proceedings going on. So, the accused is a party. He or she may be the plaintiff, they may be a defendant in the civil proceedings, and there's parallel criminal proceedings going on. And if you're acting for the accused in the civil proceeding, if you're me, I have very long shirt cuffs, and on one cuff I have Scott Fenton's phone number, and on the other I have Todd Ducharme's phone number. So at the beginning of my discovery, I'm going to call those two gentlemen up, and they're going to tell me, Wardle, when you get to the appropriate point, make sure you rely on all those provisions. And I say, write them down. So when the point comes in the discovery, I'm going to say, I'm relying on all those provisions in the Canada Evidence Act, the Ontario Evidence Act, and yet the Charter, that's it, the Charter of Rights and Freedoms. And my client's going to go ahead and then spill the beans in the civil proceeding. So the first question, and I'm going to ask Jane this question, is, assuming that happens, can the Crown get access to your client's testimony in the civil proceeding?
The rules of civil procedure outline what use can be made of anything that arises in a civil proceeding, including documents which are filed pursuant to your affidavit of documents and the evidence that is given at a discovery. What I found interesting about the Rule 30.1, I believe it is, or .01, is that once it's filed in a proceeding in the civil aspect, you can get access to it and certainly use it for purposes of impeaching the accused if he's going to take the stand. So if in the criminal proceeding the accused does take the stand, I think that the Crown cannot use it for incriminating purposes, but can certainly use it to impeach the credibility of the accused, should they do that.
And Frank, just a follow-up question to that. Is there a risk that if, particularly if the civil proceeding is well publicized or it's been in the press, that the Crown may invoke some process in order to obtain either a transcript on discovery or other information that has been floated out during the discovery process?
Well, I think there's always the danger that a party can apply, perhaps unsuccessfully, to be relieved of the implied undertaking. But I think one of the dangers, if you're practicing in civil litigation in this area, is that a person can be misled by the black letter law in the area. It's true that the incriminating testimony can't be used in a criminal prosecution of the person who made the incriminating statement. It's also true that a derivative use of that information cannot be used. A derivative use, for those of you who don't know, for those of you who do, I apologize for being trite, but derivative use means that you take the information that's contained in the testimony, if you're a police officer, and then independent of the testimony, prove the facts that are revealed in that testimony, which you think are helpful to allowing you to prosecute the individual. And then you never rely on the testimony, but you've used the testimony as a roadmap to building your case. I think if you're a civil lawyer, notwithstanding the fact that the law protects against that kind of derivative use, you have to be practical about the fact that, first of all, the burden's on the client to prove that that's happened, and secondly, that it's almost impossible to contain information once the information is out there. And so a person should not be misled into thinking that these protections are more than they really are. It's very clear in a courtroom, if a Crown attorney seeks to rely on previous testimony, that you can assert that they can't do that. But that's happening in a courtroom. There's a transcript and there's a judge and so on and so forth. But information that has been revealed at the discovery or otherwise in the course of the civil proceedings is being communicated from one law enforcement agency to another. Your ability to prove that has actually happened in the criminal case will be very, very limited. So the question, I think, is more a strategic one with your client. What is the true nature of the exposure? What is it that you're really worried about? If this is a case that involves either a person who was stealing or a person who was wrongfully dismissed, to take the example the previous panel was using, the question for the civil lawyer with the client is, like, what are you really worried about in the course of these proceedings? And if you're really worried about the fact that there's a theft that took place here, don't be deluded into thinking that you can commence these civil proceedings and impose yourself in that process and not expose yourself to being prosecuted later on.
I was saying to Peter earlier that if, obviously, we act for accused people, and we have a lot of clients who are involved in matrimonial proceedings normally, and once they come in and tell you that, I can tell you, practically speaking, the first thing I do is have somebody photocopy the entire matrimonial file, and then I'm going to use that to cross-examine the complainant when she takes the stand and alleges all sorts of assaults have taken place over time, and yet it's not mentioned in the matrimonial affidavit she has filed in those proceedings or what have you. So, you know, the rule says once the items are filed, be it the financial statements or what have you, you certainly want to have copies of those to be used in your criminal proceeding from the accused perspective.
All right, I'm going to put this to each of you. If you're acting for an accused who's also a party in a civil proceeding, and there's something that comes out of that process that is not filed publicly, that's helpful to your client's position, what can you do with it, if anything, given the requirements of Rule 30.1? Who wants to start?
Go ahead, Jane.
Well, it looks like you can make an application to be relieved of the implied undertaking rule. So you may want to contemplate that process. Or if you're crafty, you bring up some application where you're going to file all of that information, which is something that you might want to consider if you hire a smart and well-thinking civil lawyer to do that for you.
Frank?
Well, I don't think I should be giving sort of civil lawyers advice on how to commence, on what to do in a civil proceeding necessarily, but I think that it's very clear that if you can get the information before the court, then you've avoided you've complied with the undertaking, but the document has become part of the public record, and the problem has changed a little bit.
Okay, now let me push each of you a little harder on this point. Let's assume we have a document or we have some testimony on it by way of a transcript that's going to be very helpful to your client's position at trial, but is not going to be part of the public record. And it's necessary in order for your client to make full answer in defense that they have access to that material and they can use it in the criminal process. Is there a constitutional issue here? We've got a civil rule on the one hand, and we've got a constitutional right on the other.
Well, of course, that's always the argument, that your client has to be in a position to make a full answer in defense. And as I say, I mean, you have the rule in front of you, Peter, but there are certain steps that I believe you can take to be relied of that implied undertaking. As I'm not an expert in the civil context, certainly far from it. I would hire you to find a way to get that document into my hands. I can't really comment on the civil process.
Well, I think that you have to be somewhat careful in these types of situations. You have to ask yourself whether you have to understand all of the aspects of the matter. If this matter goes over more than one country, for example, if it involves some allegation of improper pricing or something of that nature, and the civil proceeding is in that vein, you have to ask yourself what use can be made of these documents, not only in the proceeding that you're concerned about, but is there an international, a use in another forum that this document can be used in, and can it have a very detrimental effect in that forum? The most common example is the production of information in a Canadian proceeding, which then becomes the subject of a class action in the United States, and especially in the area of price fixing, and the consequential damages that can be sought against the client are enormous. And so in terms of seeking the production on the public record of documents which appear to be helpful in a specific context, I think sometimes one gets overly impressed with the ability that the use that one can make of this document, and loses sight of other liabilities to which the client is exposed.
Now, let me posit this situation to you. The client, you've already been retained by the client in the criminal process. There is no civil process underway. And the client comes into your office and says, I've just been sued. What do I do?
Well, there's nothing, I believe, in the civil rules that relieves your client of not filing a statement of defense or not appearing for an examination for discovery, and the existence of a criminal charge is not going to relieve them of that obligation. You would try and certainly delay. Representing an accused, you certainly don't want your client testifying under oath or attending an examination for discovery and saying something under oath if you can avoid it. Hopefully I wouldn't have a client who would admit to anything at the examination for discovery. But there's always, as I think Eddie said initially, you know, they forget something at the examination for discovery that they remember 2 years later. That's going to hurt them. It's going to hurt them in the criminal proceeding. It's going to hurt them if they choose to testify at the criminal proceeding. So you try and avoid, and I don't want to step on the toes of one of the topics, you might want to try and stay the civil proceeding while the criminal proceeding proceeds. And that's something that I would certainly recommend to my client.
And Frank, are there ever any circumstances where if the client came to you in that situation and wanted to initiate a parallel civil proceeding for, let's assume, a proceeding that had some merit to it, that you would encourage the client to go ahead and do that?
I mean, the times that I'm acting for people, they're usually in a more defensive mode, in the sense that they're worried about some prospective liability. So I cannot think of an instance where it occurred to me to be a good idea for me to commence proceedings which would put them in the way of the judicial process. So I just sort of off the top of my head, that does not seem like a good idea to me. You might think it's smart because you can examine the other side for discovery or something of that nature, but they can examine your client if you're going to pursue those kinds of tactics. In the example that you mentioned and that Jean was commenting on, I think if you're a civil litigator, you perhaps should ask yourself the question whether it makes sense to defend the action if you're the defendant. And it may make sense in a larger tactical sense to simply let the civil proceedings go. And you see that sometimes where someone is charged with defrauding a financial institution of a significant sum of money, and the financial institution is commencing civil proceedings. It makes sense in my mind to perhaps say, well, look, we just simply are fighting on two fronts, because it's very difficult to get the civil proceedings stayed. So it sometimes makes sense to just take a more public position of, we're fighting on two fronts. We actually really can't do that. We're not able to sustain two battles at the same time, and the criminal matter can result in a very serious penalty, and so therefore reluctantly we're not partaking at all in the civil process. And to try to avoid putting yourself in the position where at least you can be examined prior to judgment being obtained, subsequent to judgment where people are trying to examine you in aid of the enforcement of the judgment, then you have to deal with how you're going to answer questions which don't go to where you've hidden the money, but go to questions which relate to the merits of the matter. I think it goes back to what, in my mind anyway, to what I said earlier. You really do have to have an overarching plan, and you have to know what the client is ultimately most concerned about, and sometimes you have to let the rest of it go. You can't fall into the habit of simply defending because you're attacked without a larger sense of purpose.
The problem I see with that, though, is if you don't defend it and the criminal proceeding occurs, can they use that admission? Are they going to turn that into an admission that your client is agreeing with things in the statement of claim, therefore they're guilty of the resultant fraud or what have you? That's a concern that might get raised. But also, if you've got a client that wants to bring a civil proceeding, of course, you don't have to just bring it against the complainant. You can bring it against various other potential witnesses in the criminal proceeding. Then you get your crack at an examination for discovery of those people, too. So in some cases, it might be strategic to bring a civil proceeding, especially if you know your client in his or her examination for discovery doesn't have anything to offer that is going to impede their criminal trial.
We got very little time left. I just want to switch gears very slightly and ask each, if you can, to comment quickly about this topic, whether or not the Crown brief is disclosable and producible by the defendant in a civil proceeding.
Well, I think, Jane?
There is a case on that is referred to in the paper, and when I was reading it, I thought what was interesting about that is that the complainant in the civil matter, the criminal matter gets stayed, then she brings a civil claim against the accused. It was a doctor, and she wanted disclosure of his statement which he gave to the police on his arrest. And the court held many things. It's a rather complicated case, but that would not be disclosed as part of the civil proceedings. So I don't think the issue has been decided. That case was different because the accused gave a statement, and that was the real issue in that case. But I think it's going to be open because the accused is obviously in the possession of the disclosure that not only has the statement of the complainant, but many things. So I don't think that issue has been put to rest. I think what made this case interesting that's in our paper is that the complainant, of course, wanted the statement of the accused to be produced, and the court held that no, it would not be.
And I agree with all that. The only comment I wanted to add was you have to disclose the fact that you have it. You can't obviously not disclose that. You just don't produce it, and it's really then what's supposed to happen is that the Attorney General is supposed to be given notice to see if they want to take a position before the court about whether or not the brief should be produced. In the case that's mentioned in the materials, the statement involved was taken the finding was that the statement was taken in violation of the accused right, of the person's right, who was the accused, right to counsel. And the court said that that statement would not be produced because the person's charter rights had not been respected.
And just for all of you, that case is DP and WAG, and it's referred to in our little paper. It's unreported at the moment, decision of Justice Blair sitting in the divisional court, and it's a very interesting read. Thanks very much.
And we'll abbreviate the coffee break about 10 to 15 minutes at maximum if you could be back in your seats. Thank you.